Hey, this is Ed Nyhouse, and before we get started today in the video, I wanted to make a quick apology to my guest. The audio on the beginning of this video wasn't great. The first two questions, the audio is a little choppy, and that is no reflection on my guest. He did an outstanding job. But the information that he provided in this video is really important for me and my clients. So I'm leaving it in there anyway, and I'll leave some chapter markers to the places where you could skip ahead if the audio is just not what you need. But since the questions in the rest of the video build upon the beginning, I thought it was important to leave in. So here's the video. Hey everybody, Ed Nyhouse, and I'm joined with Patrick Sutton, who is an attorney in Austin, Texas, specializing in short-term rental law. Patrick, thanks for coming in and helping us today. As a real estate broker, I get questions all the time about what do my clients need to look for when they're thinking about buying a short-term rental property. What do the deed restrictions need to say and not say, most importantly, before they try to make an offer on a property?
Right. It is vitally important that when you buy a piece of real property, that first of all you get a plat. You look at the plat, which may be different than the survey. So in a subdivision, it is always better to have certainly a survey, but ideally also a plat that lets you review any easements and other restrictions which might only appear on the plat. And second, of vital importance, any restrictive covenants. Often the title companies will list all of these in the exceptions to coverage in Schedule B of the title company. But often people don't actually go obtain those documents, particularly the restrictive covenants. Most of the time now when I see title commitments, there are actually links in the title commitment that you can click on to go get those documents. I cannot overstate how important it is to review restrictive covenants so that you know what you're buying. Because if you bought something that doesn't let you use the property the way you want to, you're stuck. It will be very difficult for you to ever be able to use the property the way you want. So in that contract phase, initial execution of contract phase, you need to read those restrictive covenants top to bottom. In new subdivisions, those may be long and vitally important.
Right. So what I've noticed in some of the restrictive covenants, or deed restrictions, as most people who aren't attorneys refer to them, a lot of times we see things like the property may be used for residential uses only. And I know a lot of realtors will default to that means no short-term rentals. It seems from an article you wrote on your blog that you are maybe even still currently litigating something on that front. Can you talk about that a little bit?
Sure. These challenges never die. Leasing is a residential use. And that doesn't change just because the term of the lease is 6 months, 3 months, or a week. A lease is a lease. The fact that an owner earns rent, that doesn't make it commercial, right? If earning rent made a lease commercial, then no one could rent because everybody would be engaged in a commercial operation. Now, you probably have a real estate office somewhere, and you probably arrange sales and leases at that office, and there are employees, and people drive up and park in the parking lot. That's a commercial use. If when you're at your home, you have set up a real estate office where people come and go to engage in leasing, that also is a commercial use. But the fact that a tenant comes into the house and uses the house in the way that any tenant uses a house does not make a use commercial. And so in 2018, the Texas Supreme Court told us in Tar versus Timberwood Park that the ordinary incidents of a residential lease or a short-term lease don't make the lease not residential if the tenants are doing what people ordinarily do. Now, if a tenant starts doing blacksmithing at the house, or if the tenant has sets up a lemonade stand, then the tenant hasn't gotten involved in a commercial use. But that's still, not the issue in these cases, just because someone owns a home from which they derive revenue and pay the Texas hotel tax, none of that relates to whether the house is being used as a residence. And Tar versus Timberwood Park also told us that there's no requirement that someone establish residency, like prove that they are a long-term resident in order to reside in a house. So all of that's bogus. And, you know, if at least right now in Texas, the law says that leasing for whatever duration is a residential use.
That's great news, because I know, like I said, a lot of realtors who default to the other thing, to saying no, you can't do it. And I think honestly, when they're serving as the listing agent for or the seller, uh, they're probably doing their sellers a disservice by undervaluing their property, because these properties can sell for a lot more money to somebody who can bring in the short-term rental revenue. And several properties that my clients have personally passed up on because the listing agent literally said to us, it's residential use only.
Well, I think that real estate agents and brokers do a disservice by wading into this issue with their clients. It is a quickly evolving field in the law. There are new decisions coming out all the time. I'm still litigating that issue I just told you about, where people just champ at the bit of the Supreme Court's holding. The best thing that an agent or broker can do is establish a relationship with an attorney that they can refer their clients to, or just tell the client, go talk to an attorney about this problem.
100% agree. When I was getting into real estate, someone said, be the source of the source, not the source. And so talking to people like yourself helps me do that for my clients, and maybe introduces someone to you who can seek further advice. Is there anything in a deed restriction, like if that you saw, for example, my neighborhood that I live in, they were trying to be what they thought was smart. The HOA was trying to be smart when this short-term rental thing came along, and they specifically said in the deeded restrictions, before the declarant left the neighborhood, they had it changed to say no leases under 6 months in length. Does that still seem to hold up to prevent short-term rentals, do you think?
You've just described one of the most hotly contested areas in real estate litigation. And so here's the fact pattern. On January 1, someone buys a house where the restrictive covenants do not restrict leasing, or actually say you have an unrestricted right to lease. 3 months after closing, either the original declarant amends the restrictive covenants, or the owners by a majority or supermajority vote to amend the restrictive covenants to ban any leases of less than a year. And so someone who spent a lot of money in reliance on a set of restrictions has just seen their rights vanish. Let me give you a more extreme example of that, a case I have going on up in Bell County. A veterinarian buys a 5-acre lot with a nice house on it. The original declarant happens to be still a neighbor, even though all the lots have been developed. There are under 20 lots, and a majority votes to amend the restrictive covenants after the vet buys to ban horses and barns. Whereas previously the restrictive covenants had allowed agricultural uses and had specifically allowed large animals like horses. And so she had originally, when she bought the house, been allowed to have 5 horses, 1 per acre. She buys the horses, she builds a barn, she builds a fence. Then the neighbors vote to say, yeah, you can't have horses, you can't have barns, and you can't have this fence. Now, what is more historically resonant than buying property that is designated agricultural? You rely on it to buy animals and build structures, and then your neighbors say, well, we can now amend these restrictions to take that away from you. Okay, so what is the state of the law? Texas has not squarely addressed this in any reported decision yet. There are about 15 other states that have. 12 say, yeah, you can't do that. 3 states say, well, the restrictive covenants say you can amend them, so anything goes. You don't have any rights because any of your rights can be taken away tomorrow. I've got 20 pending cases like that. I've got 4 or 5 in the courts of appeals now that are set to be decided this year. Ultimately, the Texas Supreme Court is going to have to decide this. And so the most important thing that home buyers can take away from this is watch out. If you are spending all of your money on a piece of real property in reliance on any of the rights that are in those restrictive covenants, you may see a majority of your neighbors vote tomorrow to take those away. And I can't guarantee you right now that that won't be upheld.
Interesting. So that's very much in flux, and there's no decision yet on either side of that, correct?
That's correct. No decisions.
Yeah. That is a very interesting topic. I was reading your blog, and I think you said you kind of pointed out that, and correct me if I'm wrong, but you kind of pointed out that those people that vote for the new restrictions could essentially, or you thought it would be okay for them to have a subset of restrictions, basically to further restrict their own properties, but not to impose that upon other landowners. If I understood your blog correctly.
That's exactly right. I think that what the law does say now, and should say if it's not clear, is that anyone can always further restrict their own property. And when you have multiple owners that do that same kind of restriction, they are entitled to enforce it against one another, and anyone to whom they sell becomes subject to those restrictions. And so there's nothing wrong with having half of a properties in a subdivision being mutually bound to tighter restrictions. So I call it the one-way ratchet. Owners can continually restrict their own properties, but what they can't do is take away or restrict further their neighbor's property if the neighbor does not consent.
Right.
Texas law, I was going to say Texas law historically says as follows, and this is in the Tar versus Timberwood Park decision, but it goes back a long way. Restrictions on land are disfavored in the law. And so the default is there is no restriction unless something is clear, number one, and two, the buyer had notice. Well, by definition, if there's a new restriction, the buyer did not have notice of that. And so that's why I think the courts are ultimately going to go our way, but it's going to be 3 more years before we get this up to the Texas Supreme Court.
Interesting. Okay. Well, other than the easy advice of telling somebody don't buy a property that's in an HOA and don't buy a property that's in deed restrictions, which is harder and harder to find at this point. There's still some out there, but not many. Is there any sort of poison pill that you would see in a set of restrictions that you would say just run?
Well, that is a very big question. And I'll say this, that as time goes on, the new subdivisions restrictions get longer and longer. More frequently, there are mandatory homeowners associations authorized by restrictions, and those associations are given enormous amounts of power, particularly as regards leasing and architectural control. What I'm seeing now is that subdivisions with mandatory HOAs are so, I'll say, pervasive or widespread, take your pick, that people that are wanting to build ordinary homes that vary only slightly from the cookie cutter will face a hostile architectural control committee who really doesn't want to see either any change or simply wants to exercise authority because they have axes to grind, and that's a sad fact. And so it is generating a lot more disputes. Architectural control is sort of the next major area of dispute. I'm seeing more of that than I ever have in 14 years of practice in this state, 15 years now. So, you identified the problem, which is it's hard to buy a home that's not in a subdivision, number one.
Mhm.
If you're in a subdivision, you have restrictive covenants. But it's also hard to buy a home in a subdivision that does not have a mandatory HOA with architectural control. And so that makes it vitally important that before you buy, you spend an hour with a lawyer understanding before you spend $300, $500, $800,000.
Mhm.
Spend $300 to $500 getting some advice, because that's the biggest mistake that I see.
Yeah, and architectural control is a touchy subject for realtors and brokers to talk to their clients about too. I usually default to, this is not legal advice at all because I'm not a lawyer, but I usually just say, look around the neighborhood that you're thinking about buying in. If what
Yeah.
you want to do looks like this neighborhood, there is some precedent there to do this. And that's not to say that they're going to get away with it or be allowed to do it. But if they want to do anything else, of course, we always tell them to consult an attorney. Um, and like I said, I was reading your blog, and one of the things that really resonated about architectural control committees was how over time, especially after the developer's gone, it is handed off to lay people that have generally no expertise. I have been one of them. And it was the blind leading the blind on my committee. I didn't know what I didn't know. I could read a line of text and just try to interpret, but I was not a lawyer and I was barely a real estate broker at the time. And even to the flip side, I'm now on the other side of it. I'm trying to get something in my neighborhood through the architectural control committee, and they asked for a document that I can't get because, well, they asked for a permit from the city. I don't live in the city, I can't get it, but they don't know that. They live in my neighborhood. Anyway, I don't want to badmouth them because I still would like approval, but it is the blind leading the blind for sure.
Well, the situation has improved slightly, but I'd say it's one step forward and one step back. So effective at the beginning of this year, or it might have been September 1st of last year, I forget the date. The subdivisions are required to give you an appeal from an architectural control committee to the entire board of the HOA. And the HOA board is not allowed to have any of the same people as the architectural control committee. And these people can't have, a familial relationship, right? Mm-hmm. So there is this new level of appeal, what I'll call an administrative appeal, in the subdivision. But the problem is that now, the basic problem with HOAs is that it's local government, but it's not bound by all the laws that govern local governments. So now you've added what looks like a local government appeal to a commission, basically, and yet we still don't have a body of law that surrounds these kinds of appeals. It's the new law says that the board is supposed to give the owner a packet with all the board's evidence. Well, what is this? This is lawyer stuff. So on the one hand, it's good that people get an appeal, but on the other hand, now we've just made the Lawyers Full Employment Act of 2022, right? Actually, 2020 for the next 50 years, I guess, because I'll be going to these hearings. I've already had 2 or 3. And I had one that was particularly painful where the ACC not only abandoned its position, but then lurched to the opposite extreme, which also made no sense. And, I end up in a phone call with the HOA's lawyer trying to kind of recover from lay people trying to understand a complicated set of laws and make decisions that they're not trained to make. At least in cities, you have established law, which makes, you have departments, you have commissions and boards, which then hear appeals, and those are citizens. But then there's an appeal to the local district court after that. I mean, there are all kinds of standards in place that tell us how to pursue things. And everyone understands that as you go through the levels, you have increased involvement of lawyers. To impose that kind of thing on HOAs composed of volunteers and expect them to develop evidence and have hearings, it's too much. So the legislature gives and the legislature takes.
Right. Okay. Well, I have I want to change gears slightly, but I only really have two more questions. And one is changing gears to municipalities and in short-term rentals. What is the current rule in Austin? Do you know? I mean, I hear that you should be allowed to do non-owner occupied short-term rentals, but when I call the city, they say we are not issuing new permits.
Oh,
So
I know.
does that mean I don't need a permit? I don't know.
This requires a little explanation. Do you have a minute?
I mean, I have all afternoon if you do.
Okay, in 2019, the Austin Court of Appeals tells us in a case called Zaatari versus City of Austin, Zaatari, that people have traditionally assumed that they have a right to lease for any duration, and therefore that is a protected constitutional right. And it was under a particular theory called retroactivity, which says that the government can't make a law which takes away rights you had previously. So the city of Austin, after exhausting all its appeals of that decision, decides that all the decision meant was that anyone who already had a license, and I should say this was the non-owner occupied, so-called non-owner occupied short-term rentals, which is a problem in itself because the city is requiring basically that you should prove that a house is your homestead, then you can get a type 1 license. But if it's not your homestead, you don't get a license anymore. All right, so we're talking about these type 2 non-owner occupied licenses. The city says, well, all Zaatari said is that these homeowners who already had a type 2 license can keep them, but no one else gets one. In essence, says the city of Austin, a constitutional right is evanescent and temporary and only applies to a few people. Everyone else is shut out. So clients of mine have filed a special kind of proceeding now in the Travis County Court. It's called a mandamus proceeding. And what it means is we want the court to order the city of Austin to issue type 2 licenses to everyone who pays the fee and otherwise qualifies. Because our reading of Zaatari is that the city is not allowed to distinguish between owner-occupied and non-owner-occupied housing or rentals. The city is entrenched in its position. It will not issue type 2 licenses. All I can tell you is there are other constitutional theories that we're starting to file against the city of Austin and other cities. And we hope ultimately to prevail in protecting leasing, including leasing for all durations as a constitutional right. The theory being that it's not just a narrow question of regulating the duration of leasing. What happens as a practical matter is that people who buy second homes as second residences effectively are barred from leasing because they can't both use their own home and lease it out because they would have to lease it for short terms.
Right.
Furthermore, it creates a surveillance and monitoring state where people are being scrutinized when they come and go from houses to determine whether they qualify as someone who gets to stay in a house. But in many cases, it's just people surveilling houses to see who's there and who's coming and going for no legitimate reason. And so we are hopeful that in these various cases around the state, I have several that are pursuing cities who ban short-term rentals that will ultimately prevail. We had an excellent decision out of the Fort Worth Court of Appeals 2 weeks ago, sustaining all our claims, saying that we have valid claims under several constitutional theories to defeat the city of Grapevine ban. I have another case pending against the city of New Braunfels, and then I still have cases against the city of Austin.
Well, I would like you to be successful in these so I can go buy some more, to be quite honest, and sell some more to other people. Okay, my last question, and you may not want to dive into this, but do you think the legislature will jump in and do anything to kind of, I don't know, protect our right in a Texas constitutional level to do this?
I have observed and been somewhat involved over the years in the, I should say, advocacy around this issue up at the Capitol. And I think the consensus among people who are trying to get the legislature to do something is that the issue is too hot to handle. It crosses party lines, or I should say, it really has nothing to do with party affiliation. It is an issue that makes people on both sides extremely angry, and I don't see how a politician can win voting one way or the other on this issue.
Yeah, I didn't think about that. It is very, very personal to a lot of people. And even if the HOA has no power, sometimes when I'm making those calls to these listing agents and they say, well, the neighbors don't want it, that's almost in itself the red flag, right? You don't need to see it in the document. If all the neighbors hate the fact that you're doing it, it may not be worth trying to look into.
Yeah.
Anyway, well, that's really all I had. Do you have anything else you want to add, or a little tidbit about yourself you want to throw out there?
Yeah, here's what I think. People like you who want to get involved in the short-term rental game, here's a distinction I think that's often missed. And I'll give you what I think is just the greatest example. I had someone reach out to my office last week that had a website, and I'm not going to name the specific website, but it was such and such partyhouserental.com. What is the problem? Well, first problem is party house is the buzz phrase that makes you more enemies than anything else. But does that mean if you rent a house, you can't have a party? Of course not. Anyone can rent a house and have a party. That's a residential use. So what is the problem with such and such partyhouserental.com? Well, when you go to the website, it was all about let us host your event. Let us provide catering. Let us give you barbecue and streamers. The problem is that it's not a residential use anymore, right? When you need to have an event, you rent space in a hotel or an event venue or one of those houses that has the weddings. The owner is leveraging a residential property for large scale events. And I have staked out a clear position in the courts that no one wants to live next to that in a residential neighborhood, and no one should cross the line into a commercial use. They also should not cross the line into creating nuisances, crowding too many people in a house, even if technically the number complies with state law, 3 adults per bedroom. Any landlord needs to rent to people who use a house like a house, not like a place to party. Landlords who don't do that deserve what they get, either tickets from the local government or action by neighbors in a subdivision. And so there is a middle ground here, which is be guided by how you would rent your property to any tenant. You want good people who are good neighbors. When my family and I go to our favorite place in California, we rent the same house 2 or 3 times a year. That is our home away from home. And we are neighbors when we are there. We have gotten to know people there. We are part of that community. We go to these businesses that know us when we come. That's the kind of tenants you want. Tenants like us, I guess, is what I'm saying. I mean, you want tenants who are there to be immersed in a community and live there and enjoy it for the time they're there.
Absolutely. Absolutely. And of course, you're always going to have a house that has the occasional party. But what you're saying is, as long as that's not maybe the advertised use or the purpose of the property is to throw big lavish parties, then it should be considered just normal residential use. I get it. All right. Well, I really am grateful that you had the time to chat today. I'm going to pull up your contact information here on a slide so that everyone can see how to get a hold of you and me if they need to, but you're really the expert here. So if they have a second, they can write down your information, and let me go back to you live. Anyway, I apologize for the slow start this morning or this afternoon. Technology is fun sometimes, but I really do appreciate it. You're very informative, and maybe we can do this down the road sometime after your next big win or something. You can tell me what's going on.
Well, I argue a short-term rental case in the Texas Supreme Court on February 2nd. I am hopeful of prevailing, but we'll see.
All right. Well, until then, thank you so much, and we'll talk soon, hopefully.
Thank you.